A lien is a hold or claim that someone has against the property of another as security for a debt or charge. It is sometimes said that the word lien means a string, a tie, or a bind. It implies that one is in possession of property of another that is being detained as security for a demand or obligation in respect to that property. Liens may come into being against either personal property or real property. For example, an innkeeper's lien may be placed against luggage by an unpaid hotel manager. Warehouseman's liens, artisan liens, and mechanics liens are other examples of liens placed against personal property. When real estate is sold, the buyer normally takes ownership subject to unpaid liens that are on record. However, these liens must have been recorded in order to give the lien holder protection against an innocent purchaser of the property who has no knowledge of such liens. Some liens are involuntary, arising automatically by operation of the law. This classification includes tax liens, judgment liens, and mechanics liens that are authorized and enforced by statute. Other liens come into existence against real property because of the voluntary acts of the landowner. Perhaps the most common type of voluntary lien is a mortgage, created when the owner puts up real estate as security on a loan. Some liens need to be some liens need not to be recorded in order to prevail over subsequent claims against property. Included in this category are state and county real estate tax liens, income tax and inheritance tax liens, and franchise tax liens. Valid existing liens against the property of an individual going into bankruptcy are not affected by bankruptcy proceedings. Existing liens are still in effect. When bankruptcy proceedings begin, title to the bankrupt property passes to a trustee who holds this property subject to outstanding liens. An artisan's liens, sometimes called a mechanic's liens, gives a worker the right to retain property that has been worked on until payment has been made. If the owner refuses to make payment, the artisan or worker may begin legal proceedings to obtain the right to sell the object under regulations set up by state law. If a sale results thereafter, the artisan is entitled to protect the original price to the non-payer of the work done, furnishing the rest of the proceedings to the former owner. A lien of this kind merely gives the artisan the right to hold the property. The artisan's right to sell the item does not come into being until specific legal requirements have been met. Some laws require notice to the owner prior to a legal sale by the artisan. This notice gives the owner a reasonable time to get the goods back by paying the artisan's charges. There are laws permitting a garage mechanic to hold an automobile until the owner pays the repair bill. This type of artisan's lien is sometimes called a garageman's or mechanics lien. Technically, however, the courts usually consider a mechanics lien to be one resulting from the furnishing of materials or labor for improvements on real estate rather than for working on personal property such as an automobile. In a number of states or countries, an artisan's lien is superior to other prior liens of record or to the claim of a party retaining a security interest in the goods that have been worked on by the artisan. Log on to my website www.asifjmeer.com. I also invite you to visit my blog at asifjmeer.wordpress.com. Thank you for your time. Thank you for listening. Have a wonderful day.